Good afternoon and welcome to another Parsons Behle Latimer webcast. This one titled Strategies on Acing, the SBA's new PPP loan forgiveness application. My name's Mike Bailey. I'm a lawyer with Parsons Behle Latimer, and I'll be moderating today's discussion. Before we start, I want to give a hearty thank you to Jason Castor, Parsons Behle Latimer's Chief Business Development Officer, and his team who put this together. And Jason has reminded me that I need to read an important disclaimer. This disclaimer is extremely important. Information regarding these issues changes rapidly. This webinar is not a substitute for legal advice. If there are questions about the information contained in the presentation and how it applies to your business, you should contact your legal counsel. This presentation is not intended and will not serve as a substitute for legal counsel on these issues. We're trying to make this webcast as useful as possible. So if you have questions, please use the chat feature and send your questions directly to me, Mike Bailey. I will be watching the questions closely and asking them of the all-star cast we have assembled for your benefit. That all-star cast includes 5 experienced Parsons Behle Latimer lawyers that make up our multidisciplinary PPP loan audit and forgiveness team. We have created the team because there are complicated questions that often require thoughtful lawyers from different departments to answer them together. So first, let me introduce our team. From the Corporate and Tax Department, we will have Matt Cook and Ross Keogh. Matt is the chair of the Corporate and Tax Department and has broad experience representing both borrowers and lenders on commercial loans, including SBA Section 7A loans. He has represented clients in connection with IRS audits, bank regulatory audits, and tax controversies before the IRS and in the United States Tax Court. Matt, welcome. Ross Keogh's practice focuses on matters of taxation and tax controversy, including defending clients in proceedings with the IRS. He is based out of the Missoula, Montana office. From the Employment Department, we have Sean Monson. Sean has 25 years of litigation experience, including representing companies in audits by multiple government agencies. He has the distinction of achieving a 50% reduction of a $1.4 million penalty originally imposed on his client by the United States Department of Labor. And from Parsons Behle Latimer's litigation department, we have Brandon Mark and Liz Mellon. As co-chair of the firm's litigation department, Brandon's litigation practice includes an emphasis on government program compliance issues. Brandon has written extensively on these issues and has presented at national conferences. Liz Mellon is a commercial litigator and the managing shareholder of Parsons Behle Latimer's Missoula office. Her wide-ranging experience includes litigating key TAM actions. Those are actions where a private party alleges a business has defrauded the government. Your time is valuable, so let's jump right in. We are all aware that the SBA and Treasury Department continue to develop guidance and other relevant documents in regard to the federal government's Paycheck Protection Program. The application for forgiveness and related guidance were released just last Friday. This moving target is a source of great frustration to many of our clients and is part of the reason why so many of you have signed up for this webcast. So let's start with Sean Monson. Sean, what are some of the things we learned from the application that was released last Friday?
Thanks, Mike, and welcome everyone to our webcast today. We appreciate your interest in these topics and your interest in the PPP loan program. The interesting thing about the application to me is when the PPP loan program first started, the incentive for employers was from the government, keep these people on the payroll. If you do that, the loans will turn into grants and you don't have to pay it back. So essentially the government was asking employers to act as, rather act as an employment agency rather than have their employees claim unemployment benefits, have the government pay those employees through their employers. And the big carrot for employers to do that was obviously the forgiveness piece. The forgiveness piece was a driving factor, I think, in almost every company's decision to take on one of these loans. And the frustrating part has been, we were promised guidance on April 26th. The CARES Act that created the PPP loan program required the Treasury Department to issue guidance by April 26th, and we still have not got comprehensive guidance. What we're getting is bits and pieces from a question and answer document on the Treasury's website, and then the application form, which was, as you mentioned, Mike, was just released on Friday. One of the things that, with regard to forgiveness, one of the things that's critically important is how much you use those loan proceeds for your payroll costs. Forgiveness is dependent on using those loan proceeds for at least 75% of your payroll costs. If you think about forgiveness and what you can use the PPP loan for, you can use it for payroll costs, you can use it for utility expenses, you can use it for rent payments, you can use it for mortgage interest expenses, and all those expenses can be forgiven. But the caveat is at least 75% of those loan proceeds have to be used for payroll costs. And so a lot of employers have struggled to think, I don't think I'm going to be able to meet that threshold, because how the PPP loan forgiveness program works is, probably many on this call know, is you have 8 weeks. So you get the PPP loan proceeds and you have 8 weeks to make these expenditures, and those expenditures that you make in that 8-week period using the PPP loan proceeds are what can be forgiven, but it's a tight window. And after a number of employers receive the PPP loan proceeds, they realize that it's going to be very difficult for them to use 75% of the proceeds for payroll costs. And so they've been complaining to Congress. A number of organizations have been complaining to Congress. And there's actually a bill that's pending right now in the Senate. It has not passed, to extend the 8-week period and to potentially also lower that 75% threshold. But while that was happening, Secretary Mnuchin also made a couple of comments, and he said, we're talking with Congress about this issue, but we're also going to make some technical fixes. And I think that's what you see, at least a couple of things that stand out to me among many, is what I think we're seeing is the technical fixes that he was talking about. And let me describe what I mean by that. The first, as I mentioned earlier, there's that first 8-week period after you get the loan proceeds. It's called, under the statute and also in the loan application, the covered period. And that's the 8-week period from after you get the loan proceeds for the next 56 days. The application indicates that at the employer's discretion or at the company's discretion, they can shift and create an alternate covered period for payroll costs. They can't create an alternate covered period for rent or utilities or mortgage interest, but they can create an alternative covered period for payroll costs. And what that alternative period, how that works is that the alternative period begins to run on the date of the first payroll that was paid after you receive the loan proceeds. So if you receive the loan proceeds, for example, on April 20th, and then you made your first payroll on April 26th, you can create an alternative covered period beginning on April 26th. So for the payroll costs, it runs for the 56 days after April 26th in that example. So that's one way that I think you're seeing some technical fixes from the Treasury Department to this application in trying to help borrowers match up the PPP loan proceeds with their payroll cycle. Another way that I think you see some kind of quote unquote technical fixes is that the application makes clear that payroll costs that are either incurred or that are paid during either the covered period or the alternative covered period, if that's what the employer elects to use, can be forgiven. And so if you, for example, incur a payroll cost, which under the application means it's a cost that an employee works and is entitled to the compensation. If the employee works on, for example, April 15th, but your 8-week period runs out on April 20th, but your next payroll cycle is April 25th, if you pay those incurred payroll costs even if it's after the covered period, but you pay it on the next payroll cycle after the covered period, those costs can be forgiven. And as well, if you incur the payroll costs even before the 8-week period, but you pay it during the 8-week covered period, that can be forgiven. And I know that one of our participants had a question about that he submitted in advance, kind of asking for a reference to that. And I point that participant to page 1, line 1, where it says line 1 on the loan application. It talks about that payroll costs include costs that were either incurred or that were paid either during the covered period or the alternative covered period, if that's what the employer elects to use. So, you think about it, in some ways, that's if an employer does that, they could potentially be stretching the 8-week period or payroll costs, extending it out to maybe 9 or 10 weeks, and so that they can. And I think that's kind of part of what the technical fixes that Secretary Mnuchin was talking about when this issue was raised by Congress. So those are the couple of the things that jumped out to me. There's a number of other things we learned from the application, but those are two that jumped out to me.
So Sean, thank you. Thank you so much. And before I go to Brandon Mark, we've received a question in the chat room that is right on exactly what you're talking about. So let me just read it to you verbatim and see if you can answer it.
Okay.
Is the alternative payroll period only available for employers whose schedules are biweekly or more frequently? This seems to be what the forgiveness application suggests.
I don't know if I necessarily would agree with that. I don't think that limitation is very express in the application. But my initial response is I don't think that is necessarily the case, based on what I've seen in the application.
Okay, thank you, Sean, very much. Brandon Mark. The loan forgiveness application reminds borrowers that the SBA may require information about their initial eligibility. What are some of the issues surrounding initial PPP eligibility that the SBA may be looking at?
Yeah, thanks, Mike. I appreciate the opportunity to participate. So as everybody has been sprinting forward on the PPP program for the last 6 weeks, it's now everybody is sort of catching their breath and taking the time to figure out, what did I already certify? What have I already said? And the forgiveness program or the forgiveness application reminds borrowers that the SBA is going to, and may very well go back and look at all of the information supporting their initial eligibility. As we all know by now, the PPP was dropped into the Small Business Administration Loan Program, which was obviously designed for an entirely different purpose than injecting hundreds of billions of dollars into the economy in a short period of time to stem a pandemic-driven recession. And so you have sort of incongruities between the sort of the existing program that the PPP was engrafted on and the purposes of the PPP itself and the CARES Act. The CARES Act, specifically realizing that there was going to be this tension, specifically exempted certain eligibility requirements for the SBA Small Business Loan Program. Most notably, people are aware of the exemption of the credit elsewhere requirement. And so there were other requirements as well that the CARES Act specifically exempted them. However, there is one issue that we've seen with our own clients, sort of a lurking issue, a trap for the unwary, if you will, with respect to the affiliation rules. And because those were specifically not waived under the CARES Act. And so while the initial eligibility requirements and criteria are fairly simple, you have to have a business with payroll costs, you have to have less than 500 employees, you have to make your certification in good faith of economic necessity, and some additional certifications about how you want to use those loans. The devil really is in the details, especially with that 500 employee issue. And so we just wanted to flag a few issues that we've seen with other people and other clients relating to those affiliation rules. So the basic issue here is that while you may appear to have a small business with under 500 employees, they may be under the affiliation rules of the Small Business Act considered to be affiliated with some other company, and you have to aggregate the employees of both of those companies or even a family of companies to determine whether or not the 500 employee threshold has been met. The overall rule, and these are set forth generally in regulations issued by the SBA and Treasury, is that the overall test that they're looking for is when one party can sort of control another party, or a third party can control both of them. So they really are trying to get standalone or at least somewhat independent small businesses, not companies that have basically access to other economic resources elsewhere. And it doesn't matter whether this power or this control is actually exercised. The regulations say it's enough that it exists, even if there's no evidence that it's actually been exercised. And the regulations offer some specific tests that say where these are met, there's very likely going to be a found affiliation. Some of those are based on ownership. And so if you have two companies that have a common owner, or pardon me, you have, basically you have an entity that owns another entity, there is a sort of a 50% threshold whereby if you're over 50%, they're going to be deemed to be an affiliate. But even minority owners can be deemed affiliates where they have certain powers. And this is something that we've seen in our practice where they have negative control, what's called negative control, which is they can prevent a company from doing something like issuing a distribution or to fire a CEO. If they have those powers, even if they don't have majority control, they may be deemed to be an affiliate. Other tests that the regulations talk about are affiliations based on stock options or agreements to merge. So just because you may not be the same company now, if you're about to merge with another company, they're going to consider you an affiliate of that company. There's also affiliation tests based on management. So if you have a CEO of one company that also controls another company, those companies can be considered affiliates. Then there are a whole bunch of broad tests. For example, there's a test based on what the SBA calls an identity of interest. So where you have common family members, or you have common investments that can arise. And another situation under the identity of interest is this concept of economic dependence. And this can arise in a number of situations, but where you have a supplier agreement. If a supplier has one major buyer, in particular, the test says if they derive more than 85% of their receipts from one particular party, then they're going to again be deemed an affiliate. And then after all of those tests, there's a totality of the circumstances test, which the SBA can sort of look at all the evidence and address and determine that these two companies are actually affiliates, and thereby may actually kick people out of the program and may deem them ineligible for that 500 employee test.
So Brandon, thanks for all that. There's a question that's just popped up that I think is right on point with what you're talking about right now. So let me just read it to you verbatim.
Sounds good.
Is the formula for FTEs count based on total hours paid to all employees, or is it based on FTEs bodies?
Well, fortunately, I'm going to defer to Sean Monton on that question, who is much better equipped to answer.
And that's why we have a team.
Right. So first of all, Mike, let me go back to the first question that you asked me about the biweekly or more frequent payroll. I went back and looked at the application. I see what the applicant is talking about. That does make, I think we do see some reference to that, to the alternative covered period being limited to biweekly or more frequent payroll. So I just wanted to clarify that. Yeah, so the question was, is the full-time employee equivalent, is it based on bodies or is it based on number of hours? Is that the question?
Yes, that's the question.
Yeah, it's based, you essentially, you count up all the bodies, and then there's two different ways that you can go about determining or assigning a number. First way you can assign a number is of all those bodies, anyone that works over 40 hours or more, you essentially give them a number of 1. And anyone who works less than 40 hours, you give them a number of 0.5. Or the alternative to that is you take all the full-time employees, you give them a number of 1, and the people who don't work 40 hours, you essentially take the number of hours they work and you divide it by 40, and then you round to the nearest decimal. And then you add that up, and that becomes the number of full-time employees.
Thanks, Sean, very much.
Mike, if I can just jump in to add a piece to what Brandon said is, the affiliation rules are obviously highly fact intensive and they're very technical. There are options though. So, with respect, especially, I'm thinking of negative control issues, is if you look at affiliation, you can break affiliation by taking action. So for example, if you had veto power over management taking a particular action, it would likely lead to affiliation. But you can give up that right. You can waive that right to break that affiliation. So there are things that you can remedy, on a going forward basis to break affiliation, to bring you back down in qualification. Very important issue. But those are gatekeeping issues that really need to be looked at, I think, early on to catch any errors, because the last thing you want to do is go forward to an SBA audit and find out you made a math error, you calculated your number of employees wrong, or a silly mistake that just throws you out of eligibility altogether. And especially if it's correctable, potentially now.
Matt, thank you for that very much. And it's actually your turn.
Great.
So Matt, guidance was also released in addition to the application last week, and it clarifies the standard of review for different loan sizes and creates a safe harbor for certain applicants. Can you explain the guidance to the people on this webcast?
Of course. So what the guidance essentially does is it creates a dichotomy between, I guess I'll call the standard of review, or how the SBA will look at particular applicants. And that dichotomy is broken up into two broad categories, loans under $2 million and loans over $2 million. And what this does is it's really beneficial and creates a safe harbor for loans that are under $2 million. So the required certification was that current economic uncertainty makes the loan request necessary to support the ongoing operation of the applicant. And really that's the heart of the good faith certification. And with a lot of the public whiplashing that the SBA and Treasury did with some of the public companies and things like that, there was huge concern, especially at the lower levels, of being criminally prosecuted or attaching civil penalties to borrowers that were alleged to not have made the certification in good faith. So what this rule does, and it comes out of Fact 46 of the Treasury Fact, is it creates a dichotomy and a safe harbor. So any loan under $2 million is going to be deemed to have certified in good faith the necessity of the loan. And the reasons for that is the SBA determined essentially that it has limited resources. It can only look at certain number of applications. But I think the bigger issue is that they posited that any borrower that has an under $2 million loan likely has less access to liquidity, meaning credit facilities, equity investments, equity dollars, those types of things. And the big issue for everybody that's been following the PPP program has been what I've been calling the available liquidity or other sources of capital requirement, which basically means that you've got to look to other sources of capital before you can go and get a PPP loan. That still applies to a loan over $2 million, but it does not apply because you're deemed to have certified in good faith that your loan is under $2 million. The open issue with respect to loans under $2 million is whether there will be any analysis of need in connection with forgiveness, and we're waiting for forgiveness guidance on that point. I think there's two different reads on that. One read is that you're just golden, and as long as you use the loan proceeds for permissible purposes, i.e. payroll costs, utilities, rents, mortgage interest, that you're gonna qualify for forgiveness without having to demonstrate need. It remains to be seen, but and then the second category, over $2 million loans, you're still going to have to provide what the SBA determined in Fact 46 is an adequate basis of necessity. And in connection with that, you're going to have to look at other sources of capital that you could have used to fund your business during these hard times. Now, what that does is, with respect to any loan under $2 million, it really gets rid of all the SBA leverage with respect to threatening criminal penalties or civil penalties to try to get the borrower to take a lesser amount on forgiveness. Obviously, that's still there to a certain extent on loans $2 million or over, but also what they did with loans $2 million or over is to say, okay, if the SBA determines in their review, and it's also important to note that the SBA has announced that any loan $2 million or over will be audited or reviewed by the SBA. So there will be if you have a $2 million or over loan, there will be eyes on your loan application and your forgiveness application. That's very important to know. But what it also does is it says, okay, if the SBA determines that you did not have an adequate basis for your good faith certification, an adequate basis of necessity for the certification of necessity, that if once the IRS sends you notice of that determination, as long as you pay that loan back immediately upon receipt of that notice, they won't seek any enforcement action, and they won't refer it to another federal agency. Now, obviously, the tough part about that is you've got to give all the money back in a pretty short period, and you don't have a loan carried on. So, I think this is a very important issue, especially for borrowers that have $2 million loan or over. I think, for multiple reasons. One is I think the SBA is likely to use this as leverage and threaten criminal or civil liabilities to try to negotiate a lower forgiveness amount. And so, Brandon, you've got a lot of experience in this. Could you, I think it'd be helpful if you could talk about what a good faith certification means and how do you satisfy that? Because I think if we can get our clients and, in borrowers to really focus on that aspect of it, it takes a whole sort of category of leverage away from the SBA when you're going to battle over.
Sure. And I would add two important caveats to Matt's excellent presentation, which is I'm going to sound like a broken record here for a minute. The $2 million threshold is going to be measured with respect to affiliates. And so you have to certify that you're under that $2 million when you add all the loans that any affiliated companies also got. So while you might have affiliates and stayed under the 500 employees together, and you're eligible as affiliates for the PPP loan. But when you certify for whether you're over or under the $2 million for audit purposes, you're going to have to include all the loans to any affiliates. The other main issue I would point out is that FAQ only addresses the certification for economic necessity, not other eligibility issues. And so if there are issues and problems with other certifications made at the eligibility stage at the outset, FAQ 46 is not going to provide protection. And so, as Matt was pointing out, obviously the PPP loan application contained a number of certifications that borrowers had to agree to apply. The forgiveness application also contains a number of additional certification that borrowers will have to make when they apply for forgiveness. And if you scan the application, you'll see references to U.S. code sections in Title 18, that's the criminal code, and Title 15, which relates to fraud in the SBA program more particularly. And these certifications, they seem boilerplate in the applications, right? They're pre-printed, you got to initial them. But these are the certifications that have tremendous amount of legal importance, and they are the hook upon which government enforcement agents are going to later, look at the loan applications and use those certifications to try and use the liability leverage that Matt was referring to. And to be clear, I'm not a white-collar criminal lawyer, so if you have concerns about knowing an intentional fraud, which I'm sure nobody on this presentation has, of course, but those are very serious issues, and the DOJ has already brought claims for in cases against flagrant abuse. But obviously, just below the criminal sanctions are civil fraud penalties, which I think are very much in the table in these cases. And in the civil fraud world, you can be liable even if you did not intend to defraud the government. In the civil fraud world, the argument is, I didn't know better, it is not going to save you. And one of the most powerful civil fraud tools at the government's disposal in this context is an act called the False Claims Act. There are other tools at the government's disposal, but that's sort of the Swiss Army knife for the government. And under that act, if a party acts with reckless disregard or with deliberate ignorance of information, they can be liable. So when a party is affirmatively certifying compliance with various requirements to the government, it has an affirmative duty to ensure that those certifications are made based upon a diligent and good faith review of pertinent information. It's not enough to say when the certifications were made that I didn't know any information to the contrary if the applicant didn't make any effort to look. So obviously with all of the extreme uncertainties under the meaning of the certifications, right, we still don't have definitive guidance on what the meaning of the certification on economic necessity is going to be. And obviously these potential fraud issues out there, you know, what can a business do? Well, one of the best ways to address this liability standard, and particularly the state of mind elements of that liability, is to document the diligence, right? This is where companies that took the loans can start building their audit defense files and document that diligence and show later auditors, later and government enforcement agents that we weren't reckless, we weren't deliberately ignorant. In fact, we worked hard in order to understand as much information as we could, and we acted in good faith when we made those certifications.
Brandon, that was a perfect setup for the next question to your fellow litigator, Liz Mellon. And I swear to the people watching, we have not rehearsed this. Liz, Brandon talks about information and documenting things. And Liz, you look at things like Brandon does through a litigator's prism. So talk for a few minutes about collecting information, maintaining information, and what document retention policies should be in place. Brandon talked a little bit about criminal fraud, civil fraud. Sounds like people are going to need to keep their information. How do they do that?
That's a great question. And yes, Brandon alluded to it. When I am engaged to defend a business, the first thing I want to know is what evidence do I have to mount a defense on that business's behalf. And in this specific situation, it's going to be very important to have the records, both from the point where the company made the certification on necessity for applying for the loan, as well as the information during for the forgiveness application and during the 8-week period while the loan funds were used. Now, if, as Sean mentioned, that Senate bill gets passed and that 8-week period gets extended, then documentation for a longer period needs to be maintained. It's important for businesses to know this documentation needs to be kept for 6 years regarding the PPP loan. And specific things to think about are, balance sheets at the time that the necessity determination was made, bank account statements, year-over-year comparisons on revenue, the amount of employees you had, the payroll expenses you had, those kind of basic things that you're already maintaining as a business, you kind of want to silo off. And so what's important there, if you are a larger company or a company that has a document retention policy in place, you need to look through it and figure out, okay, our email inboxes, are emails deleted after 90 days, after a year and a half? Are they automatically deleted? Is there a way to protect them? And if so, you want to pull them into a protected file. If there's not a document retention policy in place and you're a business that just kind of shoves everything in a file cabinet and then one day someone comes through and decides to throw things away, make sure you're putting this stuff in a corner where no one can get to it, or you're creating a binder with everything categorized, or a file cabinet that's locked that you're the only one that has access to. Whatever you need to do to protect this information, because 5 years from now you start to get audited and I need to defend you and we maybe have piecemeal information. We can possibly recreate some of it using bank statements, tax returns, those sorts of things. But the most that you can just put aside and save right now will save you so much time and effort on the back end, and will make it much easier for me or another litigator to put together a nice package to hand to the government and say, go find your liability somewhere else. You're not going to find it here.
That's great. Thanks, Liz.
Mike, if I can just add to that just a sec, I think it's important in this context that if you don't have a document retention policy, you should consider about putting one in place. So, the issues are going to come up as to, well, we see from metadata that, this whole class of emails was deleted. The instant sort of, speculation from that is that you purposely deleted smoking gun emails. And so, Liz, maybe you can talk about what the benefits of having a document retention policy and what happens, if you delete according to a document retention policy, as opposed to you're just deleting documents and shredding documents with, willy-nilly.
That's a great point, Matt. And it's absolutely something that businesses should consider. So if you have a document retention policy, and one of the questions that comes up from the government is, why don't you have these documents from 3 years ago when you did this application? And I can show them a document retention policy where emails are automatically deleted every year and a half. And that has consistently been followed for 4 years. And, hard copy files are purged after a year, or your online cloud storage system purges things after 2 years. When I can show that that is a normal standard part of your business and not something new, not something different, and not something that was only applied in this limited situation, I have a much better platform to defend you. The converse is also true, right? That if you don't have a document retention policy at all, and emails and electronic data and paper files just pile up for years and then all of a sudden they go missing, that's a bad fact. So you want to make sure that you are being consistent, that you are protecting the information you need to protect, but not needlessly keeping information that isn't necessary and would cost you storage fees.
Thanks, Liz, very much. And thanks for the question, Matt. Ross Keogh, we haven't heard from you yet. And you're a tax lawyer, so you're a detail guy, and we're going to need a detail guy on this question. We all know how critical the application is going to be and just getting it exactly right. What are the documents that applicants will need to attach to the application? And can you talk for just a minute about the creation of those documents? So what are the documents and how best to create them?
Yeah, thank you, Mike, and also thank you for everybody for attending. And hopefully you'll continue to ask questions in the chat, and we can help to respond and give you some additional thoughts. I want to go back to March 25th, right? The date that this program was passed. And here we are today, it's May 20th. It's been 2 months, almost nearly 60 days that we've had this program. And most people probably receive PPP funds in the first tranche, so somewhere between April 10th and April 15th. And sometime in June, June 10th to June 15th, you may have a little bit longer, your 8-week sort of run period on your PPP loan is going to expire. And it'll become time to put together the application. And as we look through what this forgiveness application does, it very much paints a picture of what we have to physically attach to that application. And it gives us, as Sean talked about and as Matt talked about, some of the broader indications of kind of the direction that we think SBA is going with how they're going to evaluate these applications, and some of the alternative ways that you might be able to include additional expenses as eligible expenses. My view at the end of the day is the application is fundamentally, it is an offer. You are conveying to the SBA that you believe, based on perhaps your coordination with counsel, and you are taking a very particular position that you are entitled to forgiveness. And so in making that offer, you are going to want to do that in a way that makes it easy for the SBA to accept it. And to the extent there are areas that SBA has not made clear, perhaps around a particular type of debt instrument or how you count a particular unique employee circumstance, you may use this as an opportunity to advocate for why the position that you took in the application was reasonable. Or otherwise, you might just choose not to disclose it, so long as you don't tip yourself into that fraud area that Brandon's talked about. And so what are those core components of that application? The first is you're going to need to document and provide a cancel check for virtually every single expense that you claim against the PPP loan. We know that's present in the lease context, and we know that's present in whether you're applying for utility payments, and it's also present in the interest expense context. You're going to want to provide the underlying instrument that defines those relationships. That might be a lease agreement, hopefully executed before February 15th, 2020. For utility bills, you'll want to include the actual utility bill. And again, with utilities, we can have those obligations that were incurred at the end of our cover period. And I think on utilities especially, this is an area of flexibility where we're probably not going to get really defined rules as what counts. And the application includes that transportation expenses are eligible utility expenses. So I'm not sure what that word means, but to me, that's an option for advocacy, that if I have expenses that might be considered in that bucket, and perhaps I've consistently reported those sorts of expenses or deducted them on a tax return as transportation, they're specifically eligible. And so in addition to those materials, on the payroll side, there's going to need to be a significant schedule that includes every single employee's name and the last four of their social security number and some sense of their compensation that's eligible for this. You also need supporting documents. So if you're making filings with state, local, or federal agencies, those are going to need to be included relative to those payroll records. And I think, and additionally and critically, we need the baseline records that you use for determining your proportional reduction by returning your workforce. So for most applicants, that is absolutely going to mean a 941 is going to need to be included. And so you probably can't get your 941 completed until June 30th or July 1st when you close that pay period. And so these applications are going to start to happen in early to mid-July. And I think that gives all applicants an opportunity now, especially since you're still in your 8-week period, to really start to tune their modeling around, have I put as much of my PPP proceeds towards eligible expenses as I can, recognizing that 75% obligation towards payroll? And are there any other places that I might want to push a little bit more so I try to burn through all of it and make sure I can get my most out of forgiveness? I do want to highlight on the 75% rule towards payroll, we are seeing litigation around Treasury's intent of developing that rule. So if you don't feel like you can hit it, you may end up filing an application that doesn't include or has less than that and take a position that you believe that rule is invalid. Those are all things that we or as legal counsel can help you figure out what are the correct boundaries to place your application in, and where are opportunities for advocacy as you construct this application.
Ross, that was great. So we've got a lot of really good questions from the chat room, and we're going to kind of do a speed round here for just a minute. And Sean Monson, the first two are going to fall to you. So let me throw these out and see if you can help our viewers. Regarding employee count, is there a place on the application? Okay, hang on, everything just shifted. Is there a place on the application to list employees that may have resigned, and then paren, which the SBA said this week that those employee reductions won't count against us?
Right. I mean, and that's the important point, is if the employee is fired for cause, if the employee resigns, or if the employee is offered a position or offered to come back and refuses, and you make that offer in writing, then they do not count against the FTE count. There's not a specific line that says here list all the employees who have resigned or have been terminated, but the instructions for the application indicated those employees do not count for the FTE reduction.
Oh, that's great. And let me give you one more speed question. I think this is a good one. Clarity. This is a viewer who needs some clarity on the count up the body statement. This employer says, I employ college kids and many left town upon the pandemic. I have the same number of FTEs, but not the same actual human beings. I'm concerned this will hurt me. What are your thoughts?
No. On the FTE count, it won't. Doesn't matter who the employee is. It's the numbers.
That was very speedy, Sean. That was good. Matt Cook, I have a couple of questions for you real quickly. The first one is, you talked about the fact that there would be forgiveness guidance that would be coming out, not to hold you to this, but do you have any sense at all when that guidance might be out?
I guess I must disclaim that we expect it, and I guess that may be an irrational hope at this point. So the CARES Act specified and gave Congress, or not the Congress, Treasury, a deadline of April 26th to put out forgiveness guidance. And then they did a few things. There was an amnesty program that if you gave the money back by a certain date, that it's been extended 3 times now, that you wouldn't be liable for criminal or civil penalties. So then we were thinking, well, of course, they extended this deadline, so they must be intent upon issuing forgiveness guidelines so that people can analyze forgiveness before they decide to give back. But no luck. The last amnesty period ran on May 18th. We're now getting close to a month past the deadline that was established by statute of all things. So I guess, I've looked foolish before in trying to predict the future and predict when that was going to come out. And to be honest, I just have really no idea. And at this point, some borrowers that got the money early on or were the first borrowers in this program are really running towards the end of their 8-week period and going to be ready to start applying for forgiveness. And, I just have no confidence that we'll have forgiveness guidance out before borrowers start applying for forgiveness. And so I think we are where we are. We know enough of the program, and, we as a group within Parsons and have established this team and thought about all the uncertainty, the open issues, and the best way to proceed forward with forgiveness. And we're anticipating that we may not see forgiveness guidance, and we have what we have, and we know how to handle this and drive it forward to the SBA review and to the forgiveness negotiations. So I guess the short answer is no idea, and we're kind of acting like we may not see it.
Okay.
Jump in on that point.
Sure, you bet.
I think to couple with what Matt said, right, we are all waiting for the forgiveness guidance. We don't know when specifically it's going to come out, but the more you can do to gather your information, have it in a place that you know how to access it, you know how to compile it and put it together, the easier it's going to be for you once we get that guidance to analyze and assess whether or not it applies to you and how you to fill out your application. So this work on the front end is really going to help you on the back end.
Mike, can I add to that as well?
You bet.
It seems to me that even if we don't get guidance, we have it almost makes it easier for an employer to say, hey, in good faith, these are the issues I looked at in certification. This is my forgiveness package. And if we don't have clear guidance, it seems like the SBA is almost ham-tied and hamstrung to try to reject those arguments.
I agree. I think that's really good.
I would just add to that point is that, we've seen this in the past is that, I guess I've sort of explained this program as building an airplane. You've got one wing and a half a wing on the other side, a frame and no engine, and you jump off a cliff with it and hope that you get it built before you hit the ground. So, at the end of the day, where this started is they have a sort of specified issued guidance that is based on available information at the time. And so if something comes out in the future and it changes sort of a basic reasonable understanding of that, you're not held to the guidance that came out after you took action. In the early case, it's, certifying the application, and then guidance sort of brought additional requirements to that. And you're not responsible as long as your interpretation of existing law and regulation and guidance was reasonable. And so likewise, making the analogy here is that, I think we're able to move forward without forgiveness based on existing guidance. And to the extent that there's something changes in forgiveness, obviously we can analyze that. We may be in a better position because if it's something that's negative, you can file your forgiveness application and potentially ignore that and have a reasonable interpretation. Because I think if you've paid attention at all to the PPP loan program, there's a lot of consternation that Treasury and SBA have exceeded their constitutional authority in changing the law as opposed to providing guidance on what Congress passed.
So on Matt's point, and I'd be curious for Brandon and Liz's thoughts, right? We're giving you a webinar today that is largely interpreting a document that was posted on the SBA's website on Friday. We've had conversations internally about what it meant why a comma was placed in a particular location. This hasn't been published in the Federal Register. We don't know if it ever will be published in the Federal Register. We've had some of Treasury's interim rules, or sorry, the SBA's interim rules that have been published. That's kind of the first step to sort of developing a rule. But the courts haven't weighed in, and we still have this CARES Act that was passed on March 25th that really truly is the law. And so I think in that environment, the opportunity for advocacy is huge. And it is very likely, but we're not going to see that advocacy be done by the time we have to file the forgiveness application.
So Ross, let me just interrupt you and just tell the viewers what you mean by advocacy. What is that?
So I mean, we have this question in the chat about auto expenses that I answered, right? It sounds like there are salespeople who, are given a stipend so they can drive vehicles around. Is that an eligible expense? And I think it is we could very easily help take the position. We might find some case law in the tax code that supports that, and to make an application that might, take more expenses than otherwise be available to that individual. And I think the application is designed to some extent to facilitate that.
But by advocacy, when would that advocacy take place, and what form would it take place in?
I think it takes place with the application. Okay. And whether you're disclosing things or certain positions you're taking that might be what you believe to be the correct interpretation, or provide additional documents, I think that is the moment that you get to set the template for future negotiations, or hopefully it gets accepted.
And Brandon, did you have anything to add to that?
Well, I would just echo what Ross said. I think there's going to be opportunities for advocacy. Absolutely. These FAQs, it's, especially, there's obviously differences between, what SBA ultimately does with the rules and whether you have to repay it, and then, whether civil penalties, civil fraud penalties are side. Those are two obviously different buckets that you're in, but at least in that second world, you're not, sub-regulatory guidance doesn't count. These have to be clear rules, have to be clear guidance. And so there's going to be, because we don't have that, we have a statute that seems to suggest one thing. We have sub-regulatory guidance in the form of FAQs that seem to suggest something else. There's already been litigation in joining some of the applications of those rules. And, there's obviously been, declaratory judgment actions brought in some of these high profile cases, but that same kind of advocacy is going to be done on an application by application basis. And I'm with Ross. I think it starts with the application, and then it's going to, continue into the audit process, and, from there, who knows?
Brandon, thanks so much. And it looks like we just have a couple of minutes left. So I'm going to ask one more question, and I'm going to go around to each member of the audit team and have you each give your answer. Brandon, I'm going to start with you. What is the one item that you would leave behind? What is the one takeaway that you want to make sure the viewers of this webcast get?
Yeah, I would, the one thing that I would ask people to take away from this is, it's never too late to start building your audit file. Yesterday was better than today. Today is better than tomorrow. You certainly don't want to be on the eve of an audit to start amassing that information, largely because, again, going back to the standards that I concern myself the most with, which is, you don't want to be upside down with the government and accused of doing nefarious things. And so, make sure that you're not acting recklessly, make sure you're documenting your diligence so that when you go into those discussions with the government, the negotiations with the government, you're coming in it with a very strong position.
That's great. Thank you, Brandon. Sean Monson, same question to you. What's the one item you would leave behind? What's the one takeaway you want the viewers to have?
One thing that I have been thinking about is that I look at this issue from not only from a lawyer's perspective, but also from kind of a business owner's perspective. My spouse applied for one of these loans, so I've been living this daily, just as all of our viewers have been living it. And one thing that, as you think about these audit files and you think about the loan forgiveness process, I think it can be somewhat intimidating, and it can get somewhat fearful. And you think, when I applied for the loan, I didn't have to. No one told me that I had to do all these things, and so when I talk to clients, they kind of feel like, did I do something wrong? And the message that I give to them, I want to give to our viewers today, is that if you didn't have all the information that we've been talking about in this webinar when you applied for the loan and when you certified for the loan, that's okay, because no one was requiring it. The government wasn't requiring it. The banks weren't requiring it. But now go back and start building that file and start backfilling that certification application, and you will be okay. If you work with, if you take these things, seriously in terms of making sure that you go through and outline what the impacts were going to be if you didn't take this loan, and write it out and save the documentation and put it in a file and don't delete it, don't destroy it, you will be okay.
That's great. Thank you, Sean. Liz Mellum, you're next. One takeaway for the viewers, if you would.
I think the biggest takeaway that everybody should have about this program goes along with what Ross was discussing with advocacy. With your business, it is your choice when to engage an advocate. If you want help while you're filling out and compiling your audit file or possible audit file, when you're filling out your application, consult legal counsel. Get someone to help you. Get someone to help answer those questions. If you don't think you need it now, then compile your information and be ready in case you do need it for an audit or a litigation with the government down the road. But understand that there are people out there like our team that can help and that are ready to assist you if you need it.
That's great. Thanks, Liz, so very much. Ross Keogh, you're next. Bring your tax knowledge to the question and give us one final takeaway for the viewers.
Well, I mean, the tax year is not closed, right? So we're still at the eve of able to spend money and move money around and allocate money inside the PPP burn period. And so those clients that model, understand, and sort of look at what are the known expenses versus those that might be a little risky, and figure out how to meet the targets, are going to be in the best position to get the most forgiveness.
That's great. Thanks, Ross. And Matt Cook, we've saved you for last. Give us your takeaway and sum up if you would.
Yeah. So while, a lot of our webinars and a lot of the information that's out there is just focuses on the uncertainty and the ambiguity in the PPP loan. And we'll say that, we're seeing that playing out now, and there's a number of lawsuits in California and others trying to clarify what these rules mean. And at the end of the day, we're looking at a good faith certification of, given current economic circumstances, the loan is necessary essentially. And there's three words in that sentence: current, necessary, support ongoing operations, that really could have a broad, extensive meaning. But I think we got to back this out and look at this. This wasn't intended to be created as a gotcha program. It's a stimulus program, and it's an aid program to help businesses. So I think with that backdrop. But the other thing too is that what businesses need is certainty. Not knowing for years or months or 6 to 24 months whether you're going to achieve forgiveness or not. This does not work well. Having that level of uncertainty in your business. So there could be further guidance, those types of things, but it's really, the way I look at this is, in tax audits and in tax controversies with the IRS, if you go in there and you think, okay, the government's on my side and we're just trying to reach an amicable resolution to this, you end up coming away from that and having to reinvent the wheel and try to get the horses back in the barn. I think having a strong advocate here, given the subjectiveness of the standards for this, is going to be absolutely critical. I think that the way this is going to play out is it's not like an all or nothing thing. I think when you get into your review audit before the SBA, it's going to be a negotiation. And, and to the extent that we can take chips off the table, like we talked about earlier, by having, an adequate basis, a strong diligence file to backstop your good faith certification, it really takes any leverage that the SBA is using on the criminal or civil penalty side off the table, so that we can get down to a real negotiation of where forgiveness should stand. And I think it's just absolutely critical that you have a strong advocate that can sort of advocate on your behalf around uncertainty, and be creative in helping you, because really, this is an industry by industry analysis. It's a business by business analysis, and so there are, having a multidisciplinary team behind you that can help you with all these things is in my view indispensable to maximizing.
Matt Cook, thank you. That's a great note on which to end this. And I look at the clock and it's 5 o'clock. So I'll say Matt Cook, Sean Monson, Ross Keogh, Liz Mellum, and Brandon Mark, thank you so much for your time. And thanks to all of you who have attended today. These have become a bit of a regular feature during this pandemic. Parsons Behle and Latimer will continue to notify you of topics as they become relevant. And until then, stay safe. We look forward to seeing you soon. Thank you very much.